Hello everyone, welcome to Apenas Fumaça. I am Ricardo Esteves Ribeiro. Today I have with me Julia Reda, member of the European Parliament for the German Pirate Party. She's one of the vice presidents of the Greens European Free Alliance group in the European Parliament, where she is also a member of the Legal Affairs Committee, as well as a substitute member of the Internal Markets and Consumer Protection Committee, and a full member of the Industry Research and Energy Committee. Julia is also on the steering committee in the Digital Agenda Intergroup, a forum of the MEPs interested in the digital issues. In November 2014, Julia was named rapporteur for the Parliament's review of 2001's Copyright Directive. She is also the shadow rapporteur of the Greens European Free Alliance for the Commission's proposal for a new directive on copyright in the digital single market. Julia Reda, welcome to Apenas Fumaça.
Hello, thanks for having me.
In September 2016, the European Commission published a proposal for a new directive on copyright in the digital single market. The proposal opens with a section called Reasons for and Objectives of the Proposal, which reads, "The evolution of digital technologies has changed the way works and other protected subject matters are created, produced, distributed, and exploited. New uses have emerged, as well as new actors and new business models. In the digital environment, cross-border uses have also intensified, and new opportunities for consumers to access copyright-protected content have materialized. Even though the objectives and principles laid down by the EU copyright framework remain sound, there is a need to adapt it to these new realities." It's been 15 years since the last directive on copyright was approved in the European Union in 2001. At that time, there was no YouTube, no Facebook, no Twitter. Wikipedia has just started. It was founded in 2001. Do you agree with the European Commission that the new directive needs to be put in place? And we'll go to the directive in detail.
Yes, definitely. I was actually advocating in my copyright report for a single European copyright law, because I do think it's a problem that we have different national laws in all 28 European countries, but people communicate over the internet and they don't really care or know whether the people they are communicating with are in the same country or a different one. So it's really impossible for people to be able to comply with these very complicated different national laws. So I think the basic idea behind the copyright reform was a good one, but unfortunately a lot of the proposals would actually make the problem worse. They would make copyright law even more complicated.
We'll go into that. I want to go to your talk at the MIT Media Lab conference Defiance in July 2007. You said, "The member states have to pick and choose from a closed list of very narrowly defined copyright exceptions for purposes such as quotation or parody, and these exceptions are differently defined in the different member states. So that means that even if you follow the copyright law of your own country to the T, the moment you put something online, you can still get sued by somebody who has seen the artwork from a different European country because, of course, on the internet, we don't have these national borders." Can you explain this?
Yeah, so if you take a very simple basic principle of copyright, such as the right to quotation, everybody agrees that it is necessary to be able to refer to somebody else's work without having to ask permission. Like, for example, if you're a researcher and you are writing about a work of art, you have to be able to quote from it. Or if you are doing a review, like, for example, of a book or a film, you have to be able to show some parts of it. But the actual national laws that define what is a quotation are really different from country to country. So, for example, in Germany, something like a meme is not a quotation because you have to be criticizing the work that you are quoting from. So even though, rights holders are not hurt by memes, like if I see 2 seconds of a film, this will not stop me from going to the movie. So I think it's a perfectly legitimate form of using somebody else's work. But in some countries, this would be considered a quotation. In other countries, it's not. And that is, I think, just too complicated for people to be able to deal with. And the result is that every single person breaks copyright law on a daily basis, because you would have to have a PhD in copyright law in all the different European countries to really know what you're allowed to do online and what not.
Online content sharing service providers shall, in cooperation with right holders, take appropriate and proportionate measures to ensure the functioning of licensing agreement where concluded with right holders for the use of their works or other subject matter on those services. In the absence of license agreements with right holders, online content sharing service providers shall take, in cooperation with right holders, appropriate and proportionate measures leading to the non-availability on those services of works or other subject matters infringing copyrights or related rights with non-infringing works and other subject matter shall remain available. This is point 1 of Article 13, use of protected content by online content sharing service providers of the proposal for the directive, the reform that we've been talking about. What does all of this legal jargon written on Article 13 actually mean in practice?
Yeah, I mean, I think the problem is pretty obvious. If you read this out, none of the listeners would actually understand what it means. And I think we should try to make laws that are actually clear. What it means, to my best understanding, is that online platforms where users can upload stuff themselves without it being moderated first, so things that become directly available as soon as somebody uploads it, there the platforms would be directly liable for the copyright infringements of their users, and they would have to ensure that no copyright infringement happens. And I can understand kind of the idea from the rights holders that they are very frustrated with the fact that users upload copyright infringing content to platforms.
Like a music on YouTube, for example.
Yeah, like music on YouTube, for example. And it's very difficult to get to the person who uploaded it. So, of course, for the right holders, it would be a lot more convenient to be able to go to the platform and ask them to pay for it. And I think in some cases that can be justified. So, for example, with YouTube and music, yes, YouTube is putting advertisement next to the music, they are monetizing it. So in that respect, it could be justified that they have to get a license. But the problem with this text is that it is not only applying to YouTube and music, but to almost all kinds of platforms, like, for example, a dating platform like Tinder that is not exploiting photographers. I mean, it wants people to upload pictures of themselves that they took themselves. And it applies to all kinds of copyrighted content. So this puts platforms in a really impossible position where they have no choice but to check every single thing that users upload before it becomes available. And this is very dangerous and could lead to censorship, because the platforms will always be interested in following the law. So they will delete everything that could potentially infringe copyright. And because there are so many user uploads, they have to use automated filters to do so. And these filters completely ignore our right to quotation, our right to parody, or anything else that is enshrined in the copyright exception.
You mean a filter that would allow them to understand even before something is actually uploaded if that is a violation, right?
Yeah, I mean, this is kind of the idea of the rights holders and some lawmakers, that technology can somehow magically fix all our problems, and that an algorithm will be able to distinguish between a copyright infringement and legal content. But in reality, such filters only exist for very specific types of content, like music, for example. But there is no filter that can, for example, detect every copyright infringement of a written text, including translations into other languages and so on. So first of all, these upload filters do not exist for a lot of types of content. And where they do exist, they regularly delete legal content because they are not very sophisticated. They delete everything that includes even short parts of a copyrighted work. But a lot of times this is actually legal because you're using the quotation exception or parody or other types of exceptions.
And what happens today? What says that the directive that now is currently the one that's put in place?
So currently there is a general directive called the e-commerce directive, which is not specific to copyright infringement, but it lays down the responsibilities of platforms with illegal content in general. And it says that platforms should not be liable for what their users do unless they actually know about it. So that means that in the case of copyright, if a right holder informs the platform, there is an upload of my material on the platform and the person who uploaded it did not license it, then the platform is required to remove it immediately. And if they don't do so, then they are liable. But what this would change would be that the platform is liable as soon as the copyright infringement happens. So it's as if the platform had committed the copyright infringement themselves. And that basically means that you cannot have free communication on this platform anymore. The platform will have to check and to pre-censor everything that users upload in order to protect themselves from being sued.
In July, 146 organizations of the creative sector and media, including music industry giants like Impala or Warner Music Group or Sony Music and so many others, including journalists, associations and media conglomerates, signed an open letter to the MEPs, members of Parliament, the European Parliament, which read, "We represent 4.5% of the EU GDP and 12 million European jobs. We are the heart and soul of Europe's plurality and rich identities. We need an internet that is fair and sustainable for all," calling the MEPs to vote in favor of the directive. Impala's executive chair, Ellen Smith, also commented, "We are confident that in September the Parliament will reach a conclusion and secure a fair and sustainable internet." So it seems like your opposition wants a fair and sustainable internet, right?
Well, these organizations that signed this open letter actually wanted us to go with the text that the Legal Affairs Committee adopted in June, which would have meant that platforms are directly liable for everything that their users do, and they have to put in place upload filters, which I think shows that they are not interested in a fair and balanced solution. Actually, also the numbers about the 4.5% of GDP are completely false. They are based on a study that assumes that half of the industry is creative industry. So they say every industry that relies on intellectual property more than average is considered an intellectual property intensive industry. And that would include things like McDonald's. So if you are flipping burgers at McDonald's, you are one of those jobs that they say are jobs created by the creative industry. So I would not overstate these kinds of numbers. And there were at least as many actually professors and intellectual property researchers who were arguing the exact opposite. That the text,
like Tim Berners-Lee, for example, the founder of the World Wide Web and others.
Yeah, and also just the intellectual property institutes of all the leading universities in Europe were saying that this text is not balanced and is only representing the interests of one side, and that fundamental rights of users are completely ignored. So I can understand that they wanted to stick with the text that the Legal Affairs Committee had come up with because they were worried about time. They did not want the procedure to take any longer. But now the European Parliament has already decided not to go with this text of the
We'll explain that later. In December 2014, an article from The Guardian titled "Google News Spain to close in response to Story Links tax" read, "Google is closing Google News in Spain and removing Spanish media outlets from the service following a row with the country's government over new legislation aimed at protecting local publishers that require the search company to pay for using their content. The Spanish government passed a new copyright law in October that imposes fees for online content aggregators such as Google News in an effort to protect country's print media industry. The law comes into effect in January." Talk about this link tax that the article mentions and also was approved in Spain, but also in a similar way in Germany in 2013, and explain how this relates to the directive on copyright that we've been talking about.
Yeah, so the idea in Germany was that publishers were seeing that Google was making a lot of money from advertisement and publishers were making less money from advertisement, and they wanted to find a way to redistribute some of that money from Google to the publishers. But the way that they were trying to do this through copyright law, I think, is fundamentally misguided. Because if a platform or a search engine or news aggregator uses copyright-protected news articles, this is already a copyright infringement. You don't need a new law for this. So
I mean, if you copy the whole news, you'd say?
If you copy the whole article or even a significant part of it, like one paragraph, that's already a copyright infringement. So if platforms are doing this and not paying for it, it's a problem of enforcement. It's not a problem of a lack of rights. But this new neighboring right or link tax,
which is the Article 11.
Yeah, it's in Article 11 of the copyright proposal, tries to introduce a new exclusive right for publishers that protects even the parts of articles that are not protected by copyright, such as just the headline or one sentence. And the problem with that is that you would not only would you not be allowed to use articles for free, this is already the case, but you cannot even link to them for free, because if you want to put a link to a news articles, you have to use at least the headline so that people know what they are clicking on. So what the publishers wanted was that Google would pay them for listing them in the search results. But the problem with that is that publishers actually want to be found on Google. They employ people as search engine optimizers and social media experts to make sure that the links look as attractive as possible. And then they're saying that the linking is actually harmful and Google should pay for it. So what happened in Germany after this law was introduced, that Google simply stopped using the snippets that they would have to pay for. So they would only show as much as the law would allow them to use for free. And publishers said, no, actually, we want Google to be required to use our content and to pay for it. But you cannot do that. I mean, you have to decide either it's harmful to be listed on Google and then you can forbid it, or it's beneficial to be listed on Google, but then you can't ask Google to pay you for it. So in Spain, they tried to do both. They introduced a law where the publisher is required to ask money for linking to them. And Google still did not pay for it. But of course, a lot of other Spanish news sites were really hit hard by this, like Meneame, for example, who can only work if you can link to news articles. Mm-hmm. And also some Spanish publishers that rely on Creative Commons, like El Diario. So this whole law just completely backfired because it completely ignores actually what the reasons for the problems of the news sector are. And I think they lie in advertisement and how the advertisement market has changed, and not in copyright. Like linking to news articles is not a problem for publishers. They actually want people to link to them.
A study titled Strengthening the Position of Press Publishers and Authors and Performers in the Copyright Directive, which was commissioned by the European Parliament Policy Department for Citizens' Rights and Constitutional Affairs at the request of jury, that you were part of, write on their executive summary. The report concludes that there are real concerns surrounding the rather uncertain effects of the right, meaning the right that the Article 11 creates, and many of the problems facing press publishers can be resolved by a much less controversial intervention. We therefore approve the proposal made in the draft jury opinion, namely the press publishers' right be abandoned and replaced with a presumption that the press publishers are entitled to copyright use rights in the contents of their publications. Explain what this presumption means and if you're in favor of this.
Yeah, I am in favor of the presumption rule as an alternative to the link tax, which would be beneficial to publishers but not cause any harm to linking and the freedom of communication on the internet. So, as I said earlier, if you use a copyright-protected article without paying for it, that's already a copyright infringement. So I'm not talking about linking to it, I'm talking about using it, like using a paragraph or something like this. But I can understand that for publishers, it's pretty difficult to actually go after websites that systematically take content from them, because usually they're not taking just one article, but they are taking hundreds of articles. And the publisher would then have to inform every single author of each of those articles, and then the author would have to go to court. And this is, of course, quite difficult to do, and most of the journalists do not have the resources to actually do that. So this presumption rule basically says that the publisher is the one who can sue and also who can issue a license to a website for the use of all the articles that were published in this newspaper. So this means the publisher no longer has to prove that they have received the exclusive right from every single journalist, but can basically sue the platform in their own right, or negotiate a license agreement with them that would cover all the articles that were published. So that means if Facebook or whichever platform is actually using articles and not paying for them, then the presumption rule would fix that. It would allow the publisher to do something about it. But if what the publishers want is actually not about using articles, it's about linking to them, then I have to say, I'm sorry, but linking is a fundamental principle of the internet. And if you don't want links to show up on Facebook or Google, you can technologically prevent that, but no publisher is ever going to do that because they actually want to be linked to. They just think that they can get their cake and eat it too, that basically they can be linked to and get money for it, which is a ridiculous proposal.
On the 12th of September, the Parliament will again vote this proposal. Explain what happened on the 5th of July and also what will happen on the 12th next week. So we're recording this interview on the 3rd of September, Monday. And also explain the different stages that the proposal still needs to pass until it gets approved or not.
Right. So with most pieces of European legislation, the European Parliament committee that is responsible for this proposal negotiates with the Council beforehand to try to find a deal that both sides are happy with, and then it's voted by the European Parliament and the Council, and it's adopted. This is kind of a fast-track procedure that is called a first reading agreement. But actually, the normal procedure for passing legislation is that the entire European Parliament gets to vote on its position. And so what happened in July was that the European Parliament decided not to allow the Legal Affairs Committee to go into these fast-track negotiations because the text that the Legal Affairs Committee adopted was not balanced enough. So that means a majority of the members of the European Parliament rejected this fast-track procedure and wants to have a full plenary debate and a possibility for Parliament to adopt amendments. And that's going to happen on the 12th of September. So we're going to have a debate probably on the day before, and all political groups can table amendments to the Commission text. We will vote on them, and this is the first reading of the European Parliament. So that means instead of having this fast-track procedure, we are going to vote on our Parliament position, and then after that we will start negotiations with the Council.
You disclosed on Twitter on the 29th of August last week that a shadow meeting took place and that Axel Voss, the rapporteur for the Copyright Directive, who was elected also by the German people and that is part of the CDU, said that you could find a compromise. A shadow meeting is basically an informal discussion between the rapporteur and the shadow rapporteurs. What came out of that meeting, and is it actually possible to find a compromise before the 12th of September? I think the amendments need to be put forward by the 5th, I guess, the September, right? Yes,
that's right. So during the shadow meeting, first of all, Mr. Voss said that he wanted to try to find a compromise. And what he said in that meeting was actually quite encouraging, namely that he wanted to change the text in a way that would not lead to automatic blocking of content. And I think that would have been a real step forward because, of course, one of the main kind of criticisms of the Article 13 is that content is blocked without a human being ever looking at it at all. And so there's no check for exceptions and limitations and whether a complaint is actually legitimate or not. So this is what he said he would do. But since then, we have actually received his new text. And if anything, it's worse than what we have seen before.
On Friday also, Axel Voss tweeted, the new proposal for #copyright directive does not foresee any measure/upload filter. Now I expect everyone who was against the previous proposal because of this to support the new proposal. But he didn't also make the new proposal public. Is this true? Is it true that the new proposal removes the needs for filters?
Well, the new proposal actually requires filters, but it's a change that is really naive. He has simply deleted everything relating to how platforms should conform with the requirement to not have any copyright infringing material. But the basic principle is still there. The text still says that platforms are directly liable for every copyright infringement of their users, full stop. So it no longer tries to explain in any way how a platform is supposed to comply with this. But from a logical point of view, if you're a platform and you are directly liable for everything illegal that your users do, you have two options. Either you get a license from every single right holder who is protected in Europe, which is impossible because there are millions of them and there is no simple way to get a license for everything because there isn't a collecting society for every type of work. So this is not possible. And then the only other option that you have as a platform is to install filters to make sure that copyright infringing content does not show up in the first place. So just because he has deleted every mention of filters, there is still the problem that the platform has no other choice, because it's impossible to get a license for everything. So the only option a platform will have to protect themselves is to install filters for everything.
Axel Voss didn't make this proposal of compromise public. Are you going to make this public?
It was already published by Politico on this weekend, I think. So it's already public.
Okay. After the vote on the 12th, a series of closed-door meetings between representatives of the Parliament, the Council of the and the Commission, called trilogues, will take place. The goal is to basically get a final text that both the Council and the Parliament are happy with. What do you think will happen there? And how transparent are those meetings too?
Well, generally, trilogue meetings are not transparent at all. So I will try to make sure that the public knows what is going on. But as a general principle, I think it's going to depend very much on what the Parliament will decide on the 12th.
Thank you, Julia Reda, member of the European Parliament and shadow rapporteur of the Commission's proposal for a new directive on copyright in the single digital market.
Thank you very much.
We'll keep following this topic. Fomos is produced by Bernardo Afonso, Frederico Raposo, Maria Almeida, Pedro Miguel Santos, Pedro Zuzardo, Sofia Rocha, Tomás Pereira, Tomás Pinho, and by me, Ricardo Esteves Ribeiro. Até já.